In the third round, we move first 6 minutes Conservative, 6 minutes Liberal, 6 minutes NDP, 6 minutes Liberal, and then 3 minutes to each of the other three interveners. So will this be Ms. Wright?
I'm going to refer Mr. Wernick to the documents that you provided to us this afternoon that we had requested last time, and I'm wondering if you can give me a little bit of help with the handwritten notes. Do you have a copy of them there?
I believe so.
Great. The handwritten notes of your COO, Deputy Secretary to the Cabinet. Midway down, it says we're looking forward to DPA, and this is what SNC-Lavalin says. Initial indication with Minister is to discussion. Can you give me a little bit more color as to what's being said there?
I believe these are the words, transcription of the words from the company.
Yeah. Do you recall what the comment was there?
Which part are you referring to?
Initial indication with respect to, I can't make out what the rest of it is. I'm wondering if you can help us.
So what the notes allow us to confirm is that on September 18th in the afternoon, the company had not been informed by the DPP that a DPA was going to be declined.
Okay. Interestingly enough, that is not what the legal officer to the DPP said in her letter to SNC-Lavalin. I understand.
It's what the company said.
Sure. You also provided for us the clerk contact with SNC. Is this everything in the contacts now? You're content that it's the entirety of your interactions with SNC-Lavalin?
It's everything that I'm aware of. When the ethics commissioner began a process, which is some time ago, there was an immediate request for all documents and records remotely related to SNC-Lavalin to be secured, and they were secured and they were sequestered. And that is probably, now that I think about it, why Mr. Butts's email traffic was secured and sequestered.
Oh, glad you understand the question now. So in your testimony previous, you said that I asked you if you were informed of the September 4 decision by the Director of Public Prosecutions. You said no. And then by midway of your testimony, you indicated, I think she advised the Prime Minister of her view that a deferred prosecution agreement was not a good course and she had no intention of intervening, and indeed she has never intervened. So as I said before, we're on safe ground to say that you and the Prime Minister both knew on September 17th that she had made her final decision and had no intention of intervening.
And as a matter of law, the decision is never final because she could always take into consideration public interest considerations and was able to take into account new information.
Okay. I appreciate that. Are you a lawyer, Mr. Wernick?
No, I'm not.
Okay. Who wrote that for you?
I have retained personal counsel because Mr. Scher's letter to the RCMP.
Right. So you're telling me that your lawyer wrote that for you?
My lawyer advised me on the boundaries of my testimony this afternoon.
Yeah, but what you just read there is interesting to me about making the assertion that everything was okay. I'm wondering who wrote that for you, because it sounds an awful lot like some other comments that were mentioned by Mr. Butts this morning and some people who appear on panels on television.
What are you insinuating?
I'm not insinuating anything. I'm saying
you are
it flat
insinuating.
out.
What are you
I'm
insinuating?
asking you who wrote that for you, Mr. Wernick.
I wrote it on my computer after conversations with my counsel.
Okay, so that wasn't so hard to say. I'm wondering if I could read to you, Mr. Wernick, what Jody Wilson-Raybould said in her testimony. She said, the clerk of the Privy Council would have known on September 17th meeting because I specifically mentioned to both him and the Prime Minister going into detail about the Section 13 notice that I received, and that, again, I was very clear that I've already made my decision around the deferred prosecution agreement and not intervening. There's no reason not to take that as a fact, is there?
As I testified last time, 90% of the conversation at that meeting and the reason for my presence was to discuss the Indigenous agenda.
I didn't ask about that. I asked you whether or not that's a fact in your mind now. Is that an agreed fact between you and I that on September 17th she went into detail about the Section 13 notice? Or do you not remember it now?
I do not believe that it was in detail or lengthy. She made her position clear as she testified that in her mind she had made a final decision.
We heard in great testimony, I'm going to actually ask the Deputy Minister of Justice a question right now. We heard in great detail from Jody Wilson-Raybould's testimony some things that I found quite disturbing as a lawyer. And I'm just going to tell you what they are. And I understand fully that you were directed on September 19th not to have any discussions with the Director of Public Prosecutions, and you didn't. And I accept that. But on September 16th, 2 members of PMO said that individual Crown prosecutor wanted to negotiate an agreement, but the director did not. They also said that they heard that you, the Deputy Minister, think she can get the PPSC to say, we think that we should get outside advice. And on the 19th, the same 2 from PMO raised the idea of an informal reach out to the director, either through the Attorney General staff or through yourself. Do you believe that direct contact between staff of the Prime Minister's office with your Crown prosecutors or the Director of Public Prosecutions or the Public Prosecution Service is appropriate?
I don't think so, but I'm not sure this is what we should read on that they had conversation with public prosecutors.
Well, we'll treat it as a hypothetical. Do you think it's appropriate for that kind of contact to happen between the Prime Minister's office staff and your Crown prosecutor or the PPSC of Canada?
That was the last question. Now I'll give the witness
Yeah.
time to answer.
So Crown prosecutors don't have conversation about specific cases with PMO. They can maybe answer questions, but as I said before, the Section 13 to explain are really dedicated to the AG.
Sorry,
Conversation.
that was okay. So now we'll go to Mr. Boissonneau.
Thank you very much, Mr. Chair. Madame Drouin, merci d'être ici.
Thank you, Ms. Drouin, for being with us today. As you know, I'm not a lawyer, so I'd like to specify a few things you said in your testimony for things to be very clear for me and perhaps for others as well. And I'm going to do this in English.
At the end of October, the Privy Council office asked you, your department, for an opinion on the potential impacts on the SNC-Lavalin issue if the prosecution were to lead to a criminal conviction. Is that yes or no?
Yes.
Did you develop that report, yes or no?
My department developed it, yes.
Would that report be considered legal advice?
Yes.
Did you provide that report to the Privy Council office?
No, I didn't.
Why did you not provide that report to the Privy Council office?
Because I knew my minister was not, comfortable for us continuing those conversations. I felt that I should test with her office before share it the piece with the Privy Council office, and I was instructed not to send it.
So the Minister of Justice and former Attorney General of Canada instructed you to not send your legal advice to the Privy Council office and by extension of that cabinet. Well,
The request I got from PCO, I'm accountable to the minister. I do also report to the clerk on the management thing. But I decided that because my minister was not comfortable with us sharing with PCO, I didn't.
Let me simplify the question. You did not provide the report to PCO at the request of your minister.
That's right.
Mr. Wernick, I appreciate all that you've done for this country and your contribution to the institutions of governance in Canada. If a report such as this were shared with Privy Council office, is it reasonable to assume that that information would at some point be shared with Cabinet in a deliberation?
The matter of prosecutions would never come before Cabinet.
Would it be something that an Attorney General might discuss with the Prime Minister, or at least need to be informed about before she met with the Prime Minister?
I think that certainly my understanding of the law, and we've talked about the Shawcross principle, is that the Attorney General, as the final decision maker, has the ability and sometimes the obligation to seek input from colleagues.
So, Madame Drouin, pour préciser encore une fois,
Just to specify things once again.
the former Attorney General went into a meeting with the Prime Minister on September 17th without the benefit of your full advice on whether to pursue independent legal advice.
Well, on December 17, she was in possession of the legal opinion I described in my opening remarks.
Okay. This is a key point because she instructed you to not raise the matter of SNC anymore. How do you reconcile this with her legal and professional responsibility to consider public policy interests, such as the impact on jobs and other considerations that we've heard here?
I mean, I think it's for her to answer that. I would like to offer that she said last week that she did her due diligence when she received a Section 13 letter. In the legal opinion that I described, we say that the first thing for an AG is really to make sure that she has all the information she needs to take her decision.
Okay, so according to your testimony then, the former minister and AG instructed the Department of Justice not to discuss, consult, or consider anything related to SNC-Lavalin after September 19th. In your opinion, did that impede the government's ability to seek legal advice on a new policy tool? And did that obstruct the government's ability to advocate lawfully for jobs? Premièrement, did that affect the government's ability to get an external opinion on a new policy tool?
Le gouvernement peut toujours aller
The government can always seek opinions when it is developing a new program, but only with the approval of the Attorney General. If your question is whether the government will seek legal advice on a criminal file in particular, the opinion I said was that even if it was suggested to seek outside legal advice, we would recommend transparency and a publication of this advice in the Canada Gazette. The fact that the former Attorney General said that she didn't want any more work on this file, did this prevent the government from seeking other legal advice on the SNC file? She is the person who decides on this file. And when she makes her decision, it means that the door is closed. She's the only one who can decide to exercise her powers under the DPP Act.
Here and provincially, is it a usual course of business or normal for an Attorney General to not forward a legal advice to the equivalent of the Privy Council, whether it's provincially or here at the federal government?
Comme je l'ai dit, je suis...
As I said, I am accountable to the minister and also to other ministers, including the Prime Minister. And if I do receive instructions, I act accordingly. Thank you.
December 19th, there was lots being said there. You mentioned, and it's been mentioned in testimony, that the Prime Minister and the former minister were at loggerheads over issues. Were they at loggerheads over an issue, any other issue other than SNC-Lavalin? Was there something else at play here?
I'm not sure that's a question I should answer because it's not covered by the SNC question.
Is there an issue that they were at loggerheads over other than SNC-Lavalin?
I think, and I do not have contemporaneous notes of the conversation. I would not say they were at loggerheads. I was worried as a Secretary of Cabinet that frustration was building, that colleagues and the Prime Minister had not been provided an explanation for why the DP8 route or option was not being chosen or exercised, and why seeking outside counsel to do due diligence on the first use of a DP8 was not being chosen. There was building frustration at the time, and I was concerned about that. The smooth functioning of Cabinet requires that ministers have a good working relationship with each other.
Thank you very much.
Thank you very much, Mr. Rankin.
Before my time starts, I just want to put on the record that I have a motion to make at the end of the proceedings again, if I may. Okay, I have a couple questions for Mr. Wernick and a couple questions for Ms. Drouin. From you, Mr. Wernick, picking up on what in the last round, I asked you a number of questions about the call you made on September the 19th to the former Attorney General, December 19th. Yes, and thank you. And you said you didn't recall a number of things I asked you. Now, we have as a fact that the Honourable Jody Wilson-Raybould and Dr. Philpott quit their jobs. They resigned from Cabinet. And you're telling Canadians that you don't remember saying any of the key things that the former Attorney General testified to. So my question is, how can you expect Canadians to believe that these highly competent, highly credible women got this so wrong?
I think there's a few plot holes in the question. It is very clear from the sequence of events that whatever triggered the Minister Raybould-Wilson's resignation happened after she was moved and after the appearance of the Globe and Mail story.
Okay. I have another one for you, and this goes to your experience in setting up fair process as a clerk, and over your 37 years as a public servant, you've seen the need for fairness in public institutions. My question is this. Do you think it's fair that the Liberals on this committee voted to invite you back to address the testimony of Jody Wilson-Raybould, but they just voted against extending her the same courtesy?
I think this is entirely for the committee to decide.
So you have no opinion, based on your vast experience with agencies, boards, and commissions, whether that's a fair process?
I work for the executive, and I will not opine on how Parliament should conduct its business.
Okay, I'd like to turn then, if I could, to Ms. Drouin. In your account, you referred to September 19th, and you write the following: I clearly recall that the former Attorney General said to me that this would be the last time we discussed the SNC-Lavalin matter, and she instructed me to not have any discussion with the DPP, close quote. So she had decided by that day. It seems clear from your testimony that you agreed to that. So unless there was any new evidence, why would one continue to raise this matter with her over and over again? Now, we heard it said that the Attorney General's decision is never final. But if there's no new evidence, no new facts, which I think you replied to Mr. Assassi on, why would that be appropriate to keep going at her when she said, and you record in your testimony, that she had made up her mind on that date?
Maybe one thing, so I cannot say whether or not new evidence, new facts was under the government hands at that point.
If it's helpful, Mr. Rankin, I firmly believe there were new facts that emerged between September and December.
Well, that's new evidence that's not been brought to this table before. And I understood you replied as a lawyer to a question from Mr. Assassi that it had to do with whether there were new facts or evidence. That's what you said.
I said.
Are you telling us there is any new fact and evidence? I understand that Mr. Wernick believes there are. What would that evidence be?
I said that I cannot talk about.
You can't talk about it.
I mean, not that I can't.
Can anybody talk about it?
Know.
You
I
don't
don't
know.
know if new facts or new evidence
I know I'm
were
sure
available at that time.
That's good to know.
Mr. Wernick is ready to answer that question if you want.
I asked the question of Ms. Drouin. Am I going to be docked on my time, Chair, as a consequence of
go
him
ahead. If you don't
intervening?
want to, please go ahead.
Well, I'm happy to have him reply if it's not costing me the very scarce seconds I have to
Well,
do
now
this.
so I'm going to stop it for a second. But no, that you should proceed with your time how you want. He offered to answer. I'm just letting you know.
I'm offering Mr. Wernick, who wishes to intervene, the opportunity to do so.
The new facts that emerged, which I believe were public interest considerations, were the tanking of the share price of the company, making it vulnerable to takeovers, and communications from the new Premier of Quebec and the Government of Quebec, which changed the risk calculus around a conviction or not conviction of the company.
Mm-hmm. All right. Thank you very much. And I apologize, we're just under such constraints. That's the way the process works. We had the testimony of a former judge here, Ms. Drouin. Her name was Mary Ellen Turpel-Lafond. And she called for an RCMP investigation into this affair. If there was any evidence that Ms. Wilson-Raybould was removed as Attorney General because she refused under pressure to change her position in favor of a deferred prosecution agreement. Do you agree with the former judge?
I think what I have to say is what I've seen in that case, and I do have an ethical obligation. If I've had seen illegal activities, it was my duty and responsibility to report it, and I have not reported anything.
Is that it, or we? I'm going to ask Mr. Angus.
Well, just finally, because Mr. Butts claimed there was new evidence, which would be reason to intervene in a direct public prosecution. But Mr. Wernick, you said this new evidence consisted of SNC's share price. When the Prime Minister's office wrote that legislation, they specifically exempted the economic argument. So Ms. Wilson-Raybould was very clear that this could not be. And yet you believe that if it's something that you think can happen, well, we'll just make it happen. If economic argument was written by the Prime Minister's office as not allowable, how do you get to claim that's new? That's not new evidence. That's new opinion.
So the phrase national economic interest in the legislation is a cut and paste from the OECD code on anti-bribery. And it is meant, in my understanding, and you can seek advice on this from experts, to distinguish national economic interest from the interest of other countries. So you can't, if you're part of this group in the OECD, You cannot favor or let a company off because it helps France versus Germany or Germany versus Italy or Canada versus the United States.
But it could be perfectly fine used in an election.
So if I could finish the question,
then the time has expired.
my view is that the economic impacts of jobs, and it's explicitly in the criminal code, the impact on suppliers, pensioners, customers, communities, is a relevant public interest consideration.
Very much. Ms. Khaled.
Thank you, Chair. And just to start off, Mr. Wernick, things that you can talk about today, is it true that you would not have been able to talk about those same things at the last time that you were before the committee, and now you're able to talk about them because of the Ordering Council?
Yeah, there's one thing specifically, which is the legal opinion which I sought and obtained in October, which I am now at liberty to share with the committee.
Thank you. I'd like to turn to the September 19th one-on-one meeting. The former Attorney General said that you raised the fact that a board meeting was to take place on September 20th with stockholders, and she deemed this to be inappropriate. She also claimed that you raised the issue of SNC's lawyer, Frank Iacobucci, not being a shrinking violet, which she also felt was inappropriate. Did you raise those issues, and do you consider raising them to be appropriate?
I don't remember the terminology. I know Mr. Justice Iacobucci because we worked on a committee together, which was the selection committee that chose the head of the Truth and Reconciliation Committee. And I was aware of him because I attended University of Toronto when he was Dean of Law and so on. If I used a phrase, I think it was intended to convey that I knew Mr. Iacobucci by reputation and somewhat personally, and he is an extremely tough legal mind.
Why were you concerned about the September 20th meeting of the SNC board?
I think I explained this earlier. It's not so much the board meeting. The board would make decisions about divulgation to shareholders and the public. They are a publicly traded company that regularly would have obligations to markets. And what they told the market would have repercussions. So the board, obviously for a company that was headed for a criminal trial, was continually, as the stewards of the company and with responsibilities to shareholders, constantly reassessing its options.
And why did you think that this was relevant information to share?
I think that I was of the view, and I remain of the view, that the potential impact on 9,000 people, the suppliers, the customers, and the communities is a relevant public interest consideration.
Now, the former Attorney General wouldn't further consider anything that you raised at the September 19th meeting, indicating that should SNC draft a letter expressing their concerns, she would forward it to the DPP. So at that point, would you say that the Attorney General had made up her mind? And from your conversations, what, if anything, would have changed her mind?
So September 19th was the first opportunity for me to follow up on September 17th. That was the week Parliament came back, as I'm sure all of you remember. And the first chance to go and see her was after National Caucus ended on Wednesday. We met in her office for about 10 to 15 minutes, in my recollection. We had a conversation which is along the lines of what the former minister testified when she was here. She was very firm that in her mind it was final, and the only route open was for the company to make public interest arguments through its lawyers. And that's where I left the matter.
Thank you. And just going towards the September 17th meeting with the Prime Minister, and you were present there, Ms. Wilson-Raybould did indicate in her testimony that the reason for the meeting was not SNC, and you confirmed that in your testimony as well. Can you talk about what 90% of the meeting was, as per your testimony?
February, I think it may have even been Valentine's Day of 2018, the Prime Minister spoke in the House and committed his government to a new approach to recognition of Indigenous rights. Fundamental change in the relationship. And it's something that he wanted to do, and I'm sure would like to still pursue. through the course of the summer, we were not making progress on ironing out the public policy and legal considerations around that. And I was in trying to keep the agenda moving through the fall, which included NAFTA, legalization and regulation of cannabis, and many, many, many other issues. I stepped in to try and conciliate and move that forward. My colleagues at PMO were immersed 7/24 in NAFTA negotiations.
Thank you. And one question to both of the witnesses. There have been comments made about the possible separation of the Attorney General and the Minister of Justice, the separation of the roles. Can you please both comment on the feasibility or whether this is a step that we should take?
I think that when you're considering a change of that magnitude, you are not talking about changing an app. You are talking about going into the deep code and the operating system of this country, and it should not be done lightly. It should be studied thoroughly. I think parties should declare themselves in the upcoming election. It might be a good topic for an expert panel, a royal commission, a Senate committee that's not running for election this summer. I do have views, which I'd be happy to share at the time, but my view is that I wouldn't do it lightly. And the UK analogy is not a perfect one because the United Kingdom does not have a statutory wall around the prosecutorial function, and Canada does.
If I can add, I've been working with that system for 6 years. I think it's a good system. I think it's working. Whether or not something else can be, brought in Canada is a policy question. And I'm ready to support doing analysis if there's a need to do that.
Thank you. Thank you very much. So we'll now go to 3 minutes from each of the small, the non-recognized parties, and then we'll excuse the witnesses, and then we'll come back to Mr. Rankin for his motion. So Ms. May?
I do identify myself to Mr. Warnock as someone who has stated publicly that he transgressed the line. I think I would suggest to him maybe he can agree that when we use the word partisan, I would never suggest for a moment, Mr. Warnock, that you were a strong lifetime liberal or a strong lifetime conservative. I think your evidence is consistent with being willing to interfere in partisan fashion for whoever is in power. But my question to you is, had you ever met Frank Iacobucci in the context of anything in the 4 months that have been described to us by Jody Wilson-Raybell's testimony? Did you have a chance to talk to him in that 4-month period about anything?
No, I do remember that he attended the Sherbrooke cabinet meeting, as I did. I crossed him in the hall. I came over and greeted him because I know him. I have never had a conversation with Mr. Justice Iacobucci about these matters.
Okay. Now, of course, in your previous history of public service, for a remarkably long time, you were Deputy Minister at the Department of Indian and Northern Affairs, and our former Attorney General, of course, was a prominent Indigenous leader with the BC Council of Indian Chiefs. I just wondered, did you have any relationship with her prior to her time as Attorney General in that context?
Yes. As I met her as early as 2006 when I started working at INAC. I attended BC Chiefs Assemblies. I was a co-panelist with her on academic conferences. I was a co-panelist with her at a number of meetings. We've had breakfasts, lunches. We've had an ongoing conversation. I had relationships with Indigenous leaders right across the country in order to do my job. And as I said in my testimony, I considered the former minister an ally in what we were trying to accomplish, a colleague and a friend.
Now, in the context of your evidence here today, I wonder if we did have the discussion about it being cut and paste language from the UNESCO agreements about OECD rather, about the OECD agreements about how to understand the term national economic interest. But it is clear that Section 715 sub 32 sub 3 says that the public prosecution must not consider the national economic interest as a factor. Isn't it a fair inference from that you would not consider a jobs argument in deciding whether to bring a public prosecution or not?
That's not my reading of the law. My understanding is in this context, national economic interest it means domestic. as opposed to the interests of other countries. And I repeat that I believe that the impacts on jobs, suppliers, customers, pensioners, and communities are a legitimate public interest consideration.
So in the public interest then, Mr. Warnock, in preparing advice to Cabinet, what work did you do to assess the threat to jobs? Did you look at the commitments made to the government of Quebec not to move headquarters, as mentioned? Did you look at the current financial status of SNC-Lavalin? Did you, in fact, have an independent assessment of whether there would be any impact on jobs from a decision to proceed as the Director of Public Prosecutions had decided to proceed?
No, because the file was entirely in the carriage of the Minister of Justice.
So, sorry, that time has expired. Monsieur Plamondon?
Merci, Monsieur le Président.
Thank you, Chair. Earlier, we talked about the PCO's request regarding legal advice that you prepared, and you said earlier, and you said that you did not send it to the PCO at the request of the minister, and now that the minister is no longer in place, could you send this legal advice to us so if the committee could take it into account? You're talking about the legal opinion on the impact if SNC were found guilty. I will look at your request and I'll ask for advice before I provide it, because it is still the draft and I will have to take some advice before I reply, but I will make the commitment to examine this possibility. Since the beginning of our discussions, well, the minister, within 8 days after she came back from her trip, to paint herself into a corner. She said that she is going to prosecute them and then she'll take no more advice or occasions to take outside legal advice. And that she wouldn't listen to anyone, and she was stubborn. She said, I'm going to prosecute them. And then later, SNC-Lavalin lost $1.6 billion over 3 months. Its share price fell by 30%. And that didn't give her cause to reflect once again on this issue. And can you give us an explanation or a reason why she was so firm in her decision and she didn't want to listen to anyone? I said earlier, for the minister and for AGs, it's very important to respect the independence of their role. And that's why they really protect their decisionary power. And I answered the question saying that, in my opinion, based on what I understood, is that she didn't see that there was any leeway in exercising her powers under the Act of DPP, that this would not be perceived as political interference. Even if she voted in favor of the Act, there are two components here. First, the Act, which introduced into the criminal code the whole system for remuneration agreements. It was a tool that was given to the Director of Criminal Prosecutions. And this was an option that the minister proposed, whether she could exercise her power under the DPP Act to overturn or to intervene in a decision that was made by the DPP to not offer a remuneration agreement. We're going to move on to the next question.
Thanks very much. Mr. Wernick, in your opening statement, you indicated the former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful. My understanding of Ms. Wilson-Raybould's testimony is that she did not believe that SNC-Lavalin was eligible for a deferred prosecution agreement under Canadian law. So I wonder if either or both of you could shed any further light on whether SNC-Lavalin would have been eligible for that provision.
What I meant by lawful was it was an option available to the minister under legislation passed by this Parliament. There was nothing illegal about a deferred prosecution agreement. It's a lawful instrument and an option that was always and still is available to the Minister of Justice.
No, fair enough, but either you or Ms. Drouin have any view on whether SNC-Lavalin would have qualified for the provision that is in legislation?
I have no line of sight to the evidence and the arguments. That is a decision which is entirely 100% in the hands of the DPP and the Minister.
Maybe just to add, so the offenses SNC-Lavalin is facing are covered under the remediation agreement regime. But as the clerk said, whether or not this tool is available on a specific case is the decision of the DPP.
Okay. On the possibility of separating the Minister of Justice portfolio from the Attorney General portfolio, Mr. Wernick, you said that it's not a decision to be taken lightly, that there should be more study, and that you might have views to present as part of such a study. Given that you're in charge of the machinery of government in this country, I'm wondering if you have any views that you could present today.
I think if you're going to go down this road, and I do think it's a productive thing to go down, then you'd have to look at Australia, New Zealand, the United Kingdom, provincial governments, and ask yourself, where is it being done, where is it not being done? My general comment on machinery changes is you trade one set of issues for another set of issues. There are consequences that are intended, and there are unintended consequences. And the people that make decisions on machinery, which actually is you in passing legislation, have to decide which set of issues you'd prefer to have.
Okay. It must happen on a fairly regular basis that companies come to the government seeking certain concessions and saying that there will be dire economic consequences and job losses if they don't get what they want. I'm wondering if you can speak any more to how the government assesses those kinds of claims or threats from companies.
Well, first of all, I mean, it's an opportunity, thank you for the question, to say something I said earlier, which is in Canada, we have a very strong transparency regime, that these contacts with government and this advocacy by companies is recorded, it's registered, and it's regulated. So that is a very good thing for Canada and Canadians. Companies, unions, university presidents, provinces, stakeholders make representations to governments all the time, and they make them to you. And so each issue would be different in terms of how it's assessed.
Okay, well, thank you.
Thank you very much, Mr. Weir. So as not to confuse anyone with what's going to happen, I propose that I will thank the witnesses, excuse the witnesses, we'll suspend for 2 minutes so that the witnesses can leave, and then we will move to Mr. Rankin's motion.
Mr. Chair, can I just clarify one point about availability of documents, because I'm trying very hard to be helpful to the committee?
Of course.
So, because I was never asked the question directly, but I just volunteered to try to be helpful to the committee, that as this issue started to bubble in September and October, I, like many people, wanted to understand the decision-making framework. Who had what role, what authority, and what power? I verbally asked my colleague for a backgrounder on the issue. That backgrounder was sent to me on October 12th in the afternoon, and I am now free to provide that to the committee. That opinion, which gave no opinion on what to do, it's simply a backgrounder on roles, responsibilities, and authorities, has been the foundation for my participation in this file ever since.
Thank you very much. We'll consider it tabled with the committee. Ms. Reid, before I thank them, did you want to ask something or say something?
Know whether or not anybody would be interested in having very short, one more round, 3 minutes each.
I'll look around. So it looks like we'll have to have a vote on that because I don't see consent.
The meeting was scheduled for 4 o'clock. We're 15, and our witnesses have been good.
Okay, so did you want to propose? Yeah.
Yes.
Okay.
I want to get to the bottom of stuff, okay?
Okay, well, in any case, I would like to then take this opportunity to thank both witnesses, both for your service to Canada and your willingness to come forward to the committee twice at a time when you're under a national spotlight. The men and women of Canada's public service across the country do an incredible job for all of us, and I know that we all, from all parties in Parliament, appreciate our public service. Et j'aimerais vraiment remercier tout le monde dans la
I'd like to thank everyone in the Canadian Public Service.
Thank you so much. We will suspend for 2 minutes and let the witnesses walk out.
Merci, Monsieur le Président.